Hello, I'm Roger Haig with Gateway Pacific Law. We're an employment law firm based in Long Beach, California, dedicated to helping individuals. In today's video, we're talking about birthright citizenship under the 14th Amendment to the U.S. Constitution. Before we get started, here's an important note. This video is for informational purposes only and does not constitute legal advice. Laws can be complex and vary based on your unique situation, so if you have specific legal questions, we encourage you to reach out to an attorney. Following the Civil War, the United States adopted the 14th Amendment. One of its principles is that if you're born in the United States, you're automatically an American citizen. This is called birthright citizenship. Recently, the President signed an executive order titled Protecting the Meaning and Value of American Citizenship, which tries to end birthright citizenship to children born in the U.S. to one or more undocumented immigrants. The order directs federal agencies to stop issuing passports, citizenship certificates, and other documents to children born in the U.S. in specific circumstances. The ACLU and over 20 states, including California, filed a lawsuit this week challenging this order. To understand birthright citizenship, we need to go back to the American Revolution, where nearly half the population in the southern states owned slaves. During the Constitutional Convention of 1787, one of the most contentious debates centered on how enslaved people would be counted for congressional representation. Slaveholding states wanted to count enslaved individuals to boost their representation, while non-slaveholding states opposed this. The result was the infamous 3/5 compromise, where enslaved people were counted as 3/5 of a person for census purposes. In 1863, President Lincoln issued the Emancipation Proclamation, and shortly thereafter, the 13th Amendment abolished slavery nationwide. With the Confederacy defeated, the 3/5 compromise was rendered meaningless. However, this led to a new question. Were former slaves and their descendants now full citizens? In 1868, Congress answered this question with the 14th Amendment and its Citizenship Clause. It is the first sentence of the 14th Amendment, and it enshrined birthright citizenship as a fundamental constitutional right. However, the Supreme Court has not directly addressed whether the Citizenship Clause applies to U.S.-born children of undocumented immigrants. But two cases decided by the Supreme Court over 120 years ago strongly suggest children of undocumented immigrants are entitled to birthright citizenship under the 14th Amendment. Let's talk about Ex parte, Crow Dog, and United States versus Wong Kim Ark. Let's first explore the meaning of the phrase subject to the jurisdiction thereof. This phrase is crucial in determining the scope of birthright citizenship because it defines the eligibility criteria for automatic citizenship at birth. Back in 1883, the Supreme Court ruled on a case called Ex parte Crow Dog. Chief Crow Dog was a sub-chief and member of the Great Sioux tribe. Chief Crow Dog shot and killed another tribal member, Principal Chief Spotted Tail. This happened on the Rosebud Indian Reservation, within the Great Sioux Reservation, which is in what's now South Dakota. The tribe handled the case under their internal laws and ordered Crow Dog to pay Spotted Tail's family restitution in the sum of $600, 8 horses, and 1 blanket. This was a large payment in those days. The territory of Dakota found the punishment inadequate and tried Crow Dog in federal court. He was sentenced to death by hanging. Crow Dog appealed to the U.S. Supreme Court. The Supreme Court held that Indian tribes at that time were sovereign entities and that Congress had not explicitly restricted the Sioux Nation's authority to govern its lands. The court decided that the federal government did not have jurisdiction over a crime committed by one Indian against another Indian on reservation land. So Crow Dog was not subject to United States jurisdiction. He was set free and returned back to the Rosebud Indian Reservation, where he died in 1912. Congress implemented new laws to govern Native Americans as a result of this case. The basic facts of the Ex parte Crow Dog case help us understand what jurisdiction means in the Constitution, even if some details don't quite line up. It shows clear examples of people with unique statuses, and shows us when certain individuals are not subject to the laws of the United States in the same way as everyone else. Applying this reasoning, unlike Crow Dog, undocumented immigrants don't enjoy a unique status exempting them from federal or state laws when they are in the U.S. We wouldn't take anyone seriously who said that an undocumented immigrant who murders another undocumented immigrant in downtown Los Angeles cannot be prosecuted for murder under state or federal law. Now let's talk about the 1898 case United States versus Wong Kim Ark. It is a landmark decision that established that children born in the U.S. to non-citizen parents are U.S. citizens at birth under the 14th Amendment, as long as their parents are subject to U.S. jurisdiction. Wong's parents came to America from China and operated a business in San Francisco's Chinatown. During this time, Wong was born in the United States. Federal law prevented Wong's parents from ever becoming U.S. citizens. They voluntarily returned to China in 1889, taking Wong with them. Wong traveled between the U.S. and China a couple of times. Each time he returned, he claimed he was a U.S. citizen and was permitted to enter the country. In 1894, Wong left San Francisco for China, as he had done before. However, when he tried to return to San Francisco in 1895, he was denied entry. Wong was detained on various ships off the coast of San Francisco while his case made its way through the court. Eventually, he won his case at the district court. The government appealed to the Supreme Court, arguing that despite being born in America, Wong was not a U.S. citizen because his parents were not U.S. citizens when he was born. Instead, they were Chinese subjects, which the government claimed excluded Wong from U.S. jurisdiction under the 14th Amendment. The Supreme Court disagreed and reaffirmed what it called the ancient and fundamental rule of birthright citizenship, and clarified that the phrase "not subject to the jurisdiction" under the 14th Amendment applies to only two specific groups born on U.S. soil that are still relevant today. The two exceptions are children of foreign sovereigns or their ministers, and children of enemies within and during a hostile occupation of the United States. Recently, a new attack on birthright citizenship was presented in the Fifth Circuit of the U.S. federal court system. In a case permitting Texas to enforce SB 4, the state's own deportation law, Texas argued that uncontrolled immigration was an invasion, as defined by the Invasion Clause of Article 4, Section 4 of the Constitution. Texas argued that in the absence of adequate federal protection, it had the constitutional authority to implement measures to safeguard its borders and residents from the perceived threats posed by unauthorized crossings. Hey, just want to take a moment to ask that if you find this video informative, please hit the like and subscribe buttons so you can see future videos we produce on other executive orders issued by the President and other relevant legal issues. Thanks, it helps a lot. Now back to the video. Judge David Ezra, the federal trial court judge, firmly rejected the notion that undocumented immigration constituted an invasion under the Constitution. The Fifth Court of Appeals enjoined Texas from enforcing the law. However, on January 20th, executive orders were signed that almost perfectly align with the arguments the defendant made the SB 4 case before the Fifth Circuit Court of Appeals. We will have to wait for the case to make its way through the court system. Over 120 years of legal precedent establishes that children of undocumented immigrants are entitled to birthright citizenship because undocumented immigrants are not immune from U.S. laws. They pay taxes, can be prosecuted for crimes, and are generally subject to U.S. jurisdiction. The smart move to fix our immigration challenges is for Congress to come together and build a system that actually works. One that handles undocumented immigrants, asylum seekers, work visas, and people wanting to immigrate legally. Trying to scrap birthright citizenship with an executive order will just kick off expensive court fights, get tied up in injunctions, and waste a ton of resources. Plus, all that legal drama would just stall real progress, leaving our broken immigration system as messy as ever. The bottom line? Working together on meaningful reforms is the only way to get it done. Thanks for watching. See you at the next video.